Dealing with CPS in Texas can be scary and stressful for parents, children, and other family members. But if you understand the process and what your rights are, it can help you make better decisions if CPS gets involved with your family.
A CPS case may have many stages, and the parents' rights at each stage may be different. Because these cases are so complicated, it's a good idea to speak to an experienced child welfare lawyer about any questions you have.
Let's start by talking about investigations, since almost all CPS cases start there. An investigation begins when someone reports that a child may have been abused or neglected. An investigator and an investigative supervisor will be assigned to the case. During the investigation, CPS is trying to figure out, was a child abused or neglected? If so, who did it? Is the child safe right now? Are the other children in the household safe? If not, what needs to happen to keep the children safe? If CPS is investigating a situation involving your child, it's important to find out what the allegations are.
This means, in what way does CPS think that the child may have been abused or neglected? Or, how is the child's home unsafe?
Parents and caregivers can be investigated for directly abusing or neglecting a child. This could include physical abuse, sexual abuse, physical neglect, or medical neglect, among other allegations.
But CPS also investigates whether a parent did not appropriately supervise a child or did not do enough to protect the child from harm or danger. This is called neglectful supervision, and it is the most common type of neglect that CPS investigates.
During an investigation, you will have the right to record all the conversations you have with the investigator. Just remember that these recordings may have to be shared if the case ends up in court. They could be played for the judge and everyone else to hear.
You also have a right to request the investigator's business card and contact information. You can ask for their business card, or you can take a picture of their badge. Every investigator has a supervisor. You can ask for the supervisor's name and contact information too.
An investigator may want to do many things like talk to your child, talk to you, look around your home, have your child examined or interviewed at a child advocacy center, ask for drug tests to be completed, ask for permission to look at medical records, and anything else they think will help gather information.
In the investigation stage, it is usually your choice whether you want to cooperate with CPS by talking to them, letting them into your home, letting them talk to your child, or do other things they ask you to do.
However, just ignoring CPS will probably not make them go away. Keep in mind that there could be good reasons to cooperate with CPS. Sometimes they just need certain information to close out the case.
If you are unsure if you should cooperate, or if CPS is asking you to do something that you do not feel comfortable with, you have the right to talk to an attorney and get the advice on what to do.
If you choose not to cooperate with the investigation, CPS may ask a judge to sign an order to aid investigation. This kind of court order could require you to let CPS do things like interview and examine your child, review your child's medical or psychiatric records, or inspect your home. Once something is ordered by a court, you must follow it, or you risk being held in contempt of court. Refusing to follow a court order could also be used against you in a CPS case.
So how will you know when an investigation is over? When an investigation is over, you should get a letter in the mail telling you what CPS investigative findings are. This means, based on the information they collected, does CPS believe the allegations of abuse or neglect were true or not? Depending on the finding and whether the case ends up in court, you may be able to have the finding reviewed and changed. If you received a ruled out finding for all of your allegations, you may be able to have the CPS records removed. Read the closing letter very carefully and reach out to the family helpline for free information if you have any questions.
And remember, the deadline to request a review is short, 45 days from when you get your letter. Just because an investigation is over does not necessarily mean the CPS case is over.
So what happens if the investigator decides that a child was abused or neglected and that the child is still at risk?
There are several things CPS can do that does not involve going to court. This can be a way to prevent CPS from taking legal custody of a child. Number 1, agree to follow a safety plan. A safety plan is a list of rules that CPS is asking your family to follow in order to keep a child safe. A caseworker may ask a family to do things like have an unsafe person leave the child's home, have the child and a protective parent move somewhere safe, reach out to resources in the community like shelters, food pantries, or medical providers, or sign a parent-child safety placement. If the family agrees, the rules should be written out in a safety plan and signed by everyone who agrees to follow the plan.
Number 2, agree to a parent-child safety placement, or a PCSP. A parent-child safety placement, or a PCSP for short, may be part of a safety plan. This is an agreement between a parent, a safe caregiver, and CPS that the child will live outside of the home temporarily while the parents address the safety issues. This should be signed by both the parent and the caregiver before the child is moved.
Number 3, agree to a family plan of service or service plan. Sometimes CPS will ask a parent to do things like classes, counseling, evaluations, or drug and alcohol treatment that are meant to help a parent become more safe and protective. These things are called services. They should be written out and agreed to in the family plan of service.
You have the right to speak to a lawyer if you're not sure whether to agree to a safety plan, a parent-child safety placement, or a family plan of service. However, these cases move quickly, so you may not have much time to make a decision.
CPS takes safety plans seriously and expects people who sign a plan to follow every rule. Breaking the rules can have real consequences, such as CPS not letting a child continue to live with a family member or CPS taking legal custody of the child.
Keep any paperwork you sign safe. Read it carefully and make sure you understand it.
So why might CPS file a court case to protect a child?
If a parent refuses to sign a safety plan or do services, and CPS thinks this puts the child at risk,
CPS may file a motion to participate in services, which starts a court-ordered services case. This asks a judge to order a parent to do services, but CPS is not asking for custody of the child.
If CPS believes that a child is in immediate danger, they may file a temporary managing conservatorship, or TMC, case, asking the judge to give CPS temporary custody of a child. When this happens, we say that a child has been legally, quote, removed from the parent or conservator's custody.
it's important to remember that if CPS legally removes your child, that is not necessarily permanent. CPS is supposed to provide services to address the safety concerns and help parents work toward reunification, which means having your child come home. These cases usually last about a year, but can be shorter or go as long as a year and a half.
CPS court cases move quickly at the beginning. The first court hearing should be set within 14 days, though that could be extended to 28 days. An important first step is to get in contact with an attorney as soon as possible to discuss your case. So, do you have to pay for a lawyer, or can you get one for free?
You always have a right to talk to a lawyer anytime you are dealing with CPS. But whether or not you can get a free one appointed by the court depends on whether CPS has filed a court case. It also depends on how much money you and your household make and what assets you own.
If CPS files a court-ordered services case or a temporary managing conservatorship case against you, and you are indigent, meaning you cannot afford to hire an attorney, You have the right to request a free attorney appointed by the court. Further, only a parent can ask for a free attorney from the court.
The process to get your appointed attorney may be different depending on what county your case is in. You will have to fill out some paperwork with your income and assets. You can talk to your caseworker or ask for the form in court.
You can find links to information about CPS cases and self-help guides on texaslawhelp.org. If you have more questions about Texas CPS, call the Family Helpline at 844-888-6565 to speak to a child welfare attorney for free. The Family Helpline cannot advise you or tell you what to do, but they can explain the law, CPS's policy, and what your rights are.